The statute and regulations recognize that emergency proceedings may need to proceed differently from other proceedings under ICWA. Specifically, ICWA was designed to permit, under applicable state law, the emergency removal of an Indian child from a parent or Indian custodian or emergency placement of such child in order to prevent imminent physical harm to the child, notwithstanding the provisions of ICWA. The regulatory definition of emergency proceedings is intended to cover such proceedings as may be necessary to prevent imminent physical damage or harm to the child. The emergency proceedings apply to both 1. Indian child who are domiciled off the reservation, and 2. Indian children domiciled on a reservation but temporarily off of the reservation. Courts have defined emergency circumstances as circumstances in which a child is immediately threatened with harm, including when a child is left without care or adequate supervision, or where there is evidence of serious ongoing abuse and that officials have reason to fear imminent reoccurrence. When a child is at imminent threat or physical safety, the child may be removed without the consent of the parent and without a court proceedings of due process. For courts to take emergency action for the removal and placement of an Indian child, they must first promptly hold a hearing, typically in 48 or 72 hours, and make an on-record finding that emergency removal is necessary to prevent imminent physical damage or harm to the child. The emergency removal immediately terminates when the court or agency has sufficient evidence it is no longer necessary. A child custody proceeding is initiated, transfer of the child to the jurisdiction of the Indian tribe, or restore the child to the parent or Indian custodian. The contents of the petition for a court to authorize the emergency removal or to continue a placement should provide a statement of harm with as much information as possible to the Indian child or the imminent threat to the child's physical safety, but lacking sufficient information will not result in denial of the petition if there is harm or the threat of harm to the child. The petition or its accompanying documents should contain the child's name, age, last known address, and the parents or Indian custodian's name and address. The petition also identifies the residence and domicile and/or jurisdiction of the Indian child, tribal affiliation, and efforts to provide notice to the parents, custodians, and tribe. A specific and detailed account of the circumstances that led to the emergency removal is presented as evidence. An emergency proceeding regarding an Indian child should not take longer than 30 days. Emergency proceedings do not provide the full range of protection of ICWA, so the 30-day limit is to ensure states promptly initiate a proceedings such as child custody proceedings that allows the full protection of ICWA for the child. However, there are circumstances that might require the extension of the emergency proceedings to extend beyond the 30 days. If returning the child to the guardian poses a threat to the child's safety, or if the court is unable to transfer jurisdiction over to the appropriate tribe, or if it has not been possible to initiate a child custody proceedings, emergency proceedings may be extended until resolved. State agencies should seek extended family or other individuals who the child is already familiar with the possible emergency placement. Agencies should strive to provide initial placement that meets ICWA's or the tribe's placement preferences to prevent subsequent disruption to a preferred placement. If not possible, agencies should locate available foster homes licensed by the state of the child's tribes pending the child's preferred placement that may be pending approval. If the child is in a non-preferred placement, the state is required to have a concurrent plan for placement as soon as possible with a preferred placement. State should ask the family and extended family to determine if the child or parent is a tribal member or the child is eligible for membership. If there is uncertainty regarding the child's tribe, state agencies should continue to investigate the applicability of ICWA until determined otherwise. The emergency proceedings would treat the child as an Indian. It is also recommended for the state to let the child's tribe know they have been removed from their home on an emergency basis so the tribe can be included in coordination of the child's care. It is recommended that state agencies work with tribes, parents, and other parties as soon as possible, even in an emergency situation, to begin providing active efforts to reunite the family. Because of the emergency removal, the statute nor rule does not require prior notice. In order to protect parents, Indian custodians, and tribes' rights to due process, it is recommended that the agency be proactive in contacting them by telephone, in person, email, or other written forms of contact.